Welcome to CLSA Law Simplified, simplifying the law for everyone. You might come across the phrase, without prejudice, or strictly without prejudice, in business or legal letters. Without prejudice is a legal phrase often used in letters, emails or other correspondences when parties are negotiating or trying to settle a dispute. But what does it mean and why it is used? Here are some useful points to know about the phrase, without prejudice. The primary purpose of using the phrase in correspondences is to encourage settlement. It is to enable parties who are genuine in wanting to settle their disputes to have an open and frank discussions between them. If parties knew that anything they said or offered could be used against them in court, they would be much less likely to make concessions or explore settlement options. This rule allows them to negotiate freely without fear of weakening their position if negotiations fail. Generally, communications marked without prejudice or made on a without prejudice basis are inadmissible in court as evidence of admissions. This means a judge cannot consider them when deciding the merits of the case. That offer can't be shown to the court unless both parties agree to reveal it, usually after a settlement is reached. For the without prejudice privilege to apply, the communication must be part of a genuine attempt to settle an existing dispute. Simply putting without prejudice on a document that isn't related to settlement negotiations won't automatically grant it this protection. The substance and intent of the communication are key. Like all legal rules, there are exceptions to the without prejudice rule, where such communications might become admissible. The main exception is when the without prejudice negotiations result in a settlement between the parties. Evidence is admissible to prove what were the agreed settlement terms. Other exceptions are, for example, where letters containing a threat is admissible to prove that a threat was made, or where a without prejudice letter containing a statement which amounted to an act of bankruptcy is admissible to prove that the statement was made. So next time if you wish to initiate negotiation to settle a dispute, it is best that you state clearly in your correspondence that you are writing on a without prejudice basis. We hope this video has helped you to understand the without prejudice phrase better. Thank you for watching. See you in the next video.